Good morning. Good morning. Good morning. It's Tuesday. It's July 25th. I can't even believe it. Today, we have a few things to talk about. It's not going to be a 4-hour stream, I promise. Why? Because Emily has places to be, things to do, places to be. But we're going to talk a bit about the Carlee Russell press conference, the missing woman from Alabama whose defense attorney put out a statement admitting that there was no kidnapping, there was no child on the side of the road. We're going to talk about a defense attorney putting out admissions like that at a press conference, what is happening behind the scenes, what I think is going on with the Crime Stoppers money, what I think should happen, and new information from Crime Stoppers that I saw as of yesterday. We're going to talk then about the TikTok defamation case. I am refreshing fervently for a ruling on this case. There was a hearing on Friday. I attended via audio the entire hearing. I'm going to break down for you what happened in that hearing. It is a federal proceeding. It cannot be recorded. It cannot be distributed. But I can tell you what happened at that hearing, the arguments that were made by the TikToker, the arguments that were made by Wendy Olson, the attorney for the professor at the University of Idaho, and kind of break down what that hearing was. So you get my play-by-play of what was going on at that hearing and the arguments that were made. So with all of that, that's what we're doing today. And then, of course, time for your questions. B2, thank you so much for the gifted memberships. That's incredibly kind. If you guys get gifted memberships, remember, you can still go in and watch the members-only live streams from this month's and past months, and go and enjoy this month's. There was a lot happening, and there's some cases going on right now around the internet. We're going to talk about that in just a minute, about what I'm covering in tomorrow's podcast. So let me know where you're coming in from, what you're drinking. Look, it's going to be a busy week. I'm not cutting back on the cold brew. We'll deal with it next week. We'll deal with it later. I don't have time. We'll talk about it soon. All right, let's roll the intro. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, y'all. Melissa asked the question that I know a lot of you are asking about. Can we talk about Taylor Schabusiness? Taylor Schabusiness is currently on trial in Wisconsin. Yes, we can talk about Taylor Schabusiness. Here's the thing. I cannot stream all day today, tomorrow. I am not going to stream the evidence and the guilt phase of the trial. Tomorrow's podcast, I break down what the facts of the case are as known, what the attorneys said during their opening statements, and what the bifurcated trial means, and talk through this is what the bifurcated trial is, and this is the phases of this trial, so that those of you who do not want to get into all of the details of this decapitation murder, that is a lot, those of you that don't want to get into all of those facts can get a more neutralized version of the facts, as much as you can make decapitation non-sensationalized and neutral. And then you can go through what the bifurcated trial means. After we get past the guilt phase, I think this will probably be a quick verdict. When the defense attorney's opening statement starts with all of the constitutional rights and not the facts of the case, you know that there's not much for the defense to argue. Once the defense is arguing constitutional rights, there's not much else for them to do in the case. So I think it will be a fairly quick verdict, and then it will get into the second phase of the case, which is the NGI phase of the case, or the not guilty by reason of mental disease or defect. That's when we will get into the experts talking about methamphetamines, involuntary intoxication, and whether or not Taylor Schabusiness has a mental diagnosis that would actually cause her to be not culpable for her crime due to that. That is the part of the case I think that we can have a lot of conversation around. And just because the behavior of Taylor Schabusiness at the crime scene seems well outside the bounds of what you expect from people. It does not necessarily mean she is not culpable for what she did. So she will so I think we will be getting to a NGI phase of this trial. I think the jury will probably come back quickly, and then when we get into the NGI phase, we will see that. Darren Emily Riding said the defense isn't doing much defending. There's not much they can do. She admits it a lot. She's caught with the victim's blood on her. She tried to clean it up. There's not much the defense can do. What they're going to do is really fight at the NGI plea. So that's where we're going to. Look, meth is bad. So why is the default not guilty by insanity and not guilty but with mental? The NGI, in most states, it's been retitled to not guilty by reason of mental disease or defect. She pled both. I talk about that in tomorrow's podcast. I talk about the two pleas. It's kind of a plea in the alternative. She was caught literally red-handed. That's what the prosecution said in the opening statement of the case yesterday. It's going to go fairly fast. Why did she decapitate somebody? We might find out during the trial. If I had to give you my suspicions, it's because methamphetamines are bad. So we will see. But again, that's tomorrow's podcast. That is my breakdown. After we get past the guilt phase of the trial, I will be covering the NGI part. So it's going to be interesting. If you guys are watching it, I'm sure you are very interested. She seems very interested. It is a rough fact pattern. It is not good. So that's tomorrow's podcast. We will see. So if you want to know what's going on in that case, tomorrow's podcast. Sam's like, I feel like I'm out of loop. Tomorrow's podcast will loop you back in if you don't want to get into it. So with all of it, I see the chat. I see you. Drugs are bad. Okay. Look, at the DA's office, I dealt with a lot of people who had done a lot of different varieties of drugs. And people on heroin falling asleep, like behind the wheel on the freeway, always freaked me the fuck out because like that can cause a whole lot of problems. The cases where people were on meth are some of the wildest, scariest shit I have ever seen. And then the people who had the lasting effects when they were not on meth was scary stuff. Like scary stuff. There is not a ton in the world that scares me. There's a lot that I can understand. Scary stuff. So of all of the things, the bath salt scare was something, but the meth has been a terrifying thing. So it's wild. So anyway, let's see. With that, I see a lot of questions. We're not turning into a true crime channel. I promise you. We also cover civil cases here. But with that said, Carrie Jo and a lot of you have asked in the chat if I'm going to be covering Lisk. I am not caught up. I will be covering Lisk. I am like the rest of you, where I have a lot of questions. So yes, I will. There's a lot to cover in that case, and I am not all the way caught up. I am also looking at the new search warrants that were served with regard to Tupac. So there is stuff that I'm looking at, and there are cases that I need to catch up on, and it's also still summer concert season. So I am but one person, but I am trying to catch up. Lisk has been moving quickly. So I am trying not to just only cover criminal stuff. It was never my goal to just cover criminal stuff. I like covering the pop culture stuff, but I think when you have a serial killer who has been outstanding for decades, there is definitely a lot of crossover between what we are talking about in conversation and what I'm asked about. I've gotten asked a lot. LISK stands for the Long Island Serial Killer. Sorry. So I am not trying to get into all crime, but there are things that we are talking about that are in the criminal realm, and it seems like heavily in the criminal realm right now. And that case is a fascinating case. There are lots of victims. He is not charged with all of the victims. There are things we are going to need to talk about there about police investigations and have they found him, and the South Carolina of it all. There's lots to talk about. So, question any more on the Motley Crue lawsuit? There is, and we will get to it. We will get to Motley Crue in a few days. Yes, we will. So with all of that, we need to, why do I feel like I've missed something? I need to make sure I didn't skip a podcast last week. You probably didn't. We're just that far behind, and we're just in the housekeeping portion of like, there's a lot that I want to look at. I'm not going to be able to look at all of it, but there's a lot we want to look at. So today we're going to start with the Carlee Russell press conference. I'm going to give you my thoughts on it. You've probably already watched the Carlee Russell press conference. It's fairly short. I want to talk about the legal side of it. What can happen from here when we get a defense attorney making statements like that? What's going on? I also saw the question, did you see the Barbie movie this weekend? I did not see any movies this weekend, but my family very much wants to go see Mission Impossible. So we might just go watch 2 hours of like Tom Cruise's hair moving around, but I don't know yet. Question, any update on the 7M lawsuit? I have not looked at the 7M lawsuit in a long, long while, so I do not have an update on that for you today. Okay. We're going to go to the Carlee Russell press conference. We're going to talk about defense attorneys making admissions before charges are brought, because I talked about this case before. I think we need to talk about I don't often talk about things before they get to court. This case is going to get to court. There's been a lot of questions about the money. There's been a lot of questions about the defense attorney making these admissions. I've gotten a ton of DMs about it. And when I cover things that we're all talking about, well, this is definitely something that we are all talking about. So let us add this to the This is coming from WFLA. They do such a good job. I really like how JB covers the news. I like how JB addresses, because he does interactive like I do, addresses like, hey, these are rumors. We're not addressing rumors. We're sticking to these things. I really like the way that they do coverage. And I've really liked the way that Hoover Police has navigated this situation. I think that they've been tremendously patient, restrained, and respectful. Also, the police chief has the best suits, right? I love it. It's been very interesting to watch this whole thing play out. It's also wild. And it's sad. The overwhelming feeling I'm left with all of this is sad. Truly, just sad. It is a sad circumstance. So for those of you that are just tuning in, let's swoop a doop. Carlee Russell went missing. She had called police, called 911, said that there was a toddler that she saw walking down the side of the highway, pulled over on the side of the highway freeway, like a large throughway. And then we saw the roadside camera, saw her car, saw what looked like her getting out of the car and then gone into the night. Her family was on the phone with her. They heard her ask, "Are you okay?" Heard a scream. And then by the time police got there from that 911 call 5 minutes later, her wig was there, her cell phone was there, her Apple Watch was there, food that she had picked up from Tzatziki's for dinner was there. They have Tzatziki's here in Tennessee too. They're actually really good. Was there. And then later it came out that she had also stopped at Target. The things from Target weren't there. She had taken a bathrobe and some toilet paper and some other stuff from work. That stuff wasn't there. There was other stuff that was missing. And then they went to computer searches and phone searches, and the story began to unravel a bit. But also she disappeared into the wooded area, and it still remains unknown where she was during the 49 hours that she was missing. What I will say is that in that amount of time when she walked back home, it is unusual for people to just say, oh, I just got away. There's normally more to that than I just got away or they just let me go. And I think that started a lot of the questions and conversations. Of course, there were questions before that about this is a wooded area on the side of the road. We don't see anybody else pull up. It doesn't, in the video, it doesn't seem that there's anything else going on the side of the road. So there were questions, but I think at the time before she was home, the bigger question and the overriding question of the internet was she needs to be found. Like people had questions, but it was like she needs to be found. And then if there's questions, there's questions. Or at least that's what I saw on the internet. That I don't obviously see everything, but the overwhelming sense I got was people were like, I have questions, but also she needs to be found. And that she needs to be found was overriding. Once she returned home, those questions started to bubble up more. Police held a press conference because then people are like, is there a missing child? Is there someone grabbing women off the side of the road and taking off anything you could track them with? Is there someone using a child to lure people to the side of the road? Like the community had a lot of questions and concerns, as they should. And so the police came out and said, look, there's no threat to the public. So this was a second press conference that was called yesterday. This press conference was called with fairly short notice, given a press conference. And we're just going to go through that together. So let me know if you can hear this okay as we get rolling.
Thanks to everyone for attending again today. I want to thank the members of our department and all of law enforcement who played a role in the investigation of this case. Last Wednesday, July 19th, we held a press conference and provided you with the facts of the Carlee Russell disappearance.
I'm going to turn this up just a little bit. I love how they we provided you the facts of the disappearance.
We told you the investigation was ongoing. We helped you determine where Carlee was during the 49 hours of her disappearance. Today I've talked to and received a statement from Mr. Emory Anthony, attorney for Carlee Russell.
Emory Anthony is a very, very well-regarded criminal defense attorney. And that is to note, when people hire criminal defense attorneys, it's because they are generally worried about charges being brought.
Mr. Anthony has scheduled a meeting for Carlee to meet with investigators early this afternoon, but then I received an email stating that a statement was being provided by him on her behalf. Mr. Anthony asked that I read the statement in its entirety, which I will do now.
It's interesting to me that they had set up a meeting and they were going to sit down and have a meeting. And then instead it was here's a written statement. Of course, Carlee Russell doesn't have to speak to police at this point, has a right to remain silent. Making a false police report at the beginning is a crime. There might be other things here that are also criminal behavior. So there is a concern that there could be a filing, which means she's in the right to say, I have the right not to say anything. So I'm not surprised that meeting was canceled. I think the defense attorney will probably meet with the prosecution. We'll talk about that in a minute. So the defense attorney provided a written statement to law enforcement to read at a press conference.
My client has given me permission to make the following statement on her behalf. There was no kidnapping on Thursday, July 13th, 2023. My client did not see a baby on the side of the road. My client did not leave the Hoover area when she was identified as a missing person. My client did not have any help in this incident.
No kidnapping, no baby, did not leave the area, and did not have any help, which is important because I think that she wants to make sure her parents and those who know her aren't implicated in assisting her or helping her with this, because then again, you might I don't even know if law enforcement charge like aiding and abetting a misdemeanor false police report, but there could be an aiding and abetting after the fact when she came back and law enforcement asked her for a statement, and her statement at that time might be obstructive. So I can imagine why the attorney would want to be careful that no one else is implicated. I don't know, and I don't know if we know if her family knew. I don't think her parents knew, based on what they saw. After she came home, did her parents know? I don't know. But if her parents gave her, or her parents gave her aid, there could be concern about that once she returned. I don't think her parents gave her aid when she was missing. I think they were terrified for 49 hours. But also, how do you do that to your family members? Because they seemed terrified, but I don't know. Maybe we'll know more. Maybe we won't. But her parents seemed terrified. Once she returns, they kept saying she was fighting for her life. Was she lying to them as well? I don't know.
But this was a single act done by herself. My client was not with anyone or any hotel with anyone during the time she was missing.
Not with anyone, not with any hotel with anyone. Where was she? Because it seems from what was reported, and again, we can only go off of what was reported. It seems from what was reported that she wasn't out in the elements for 49 hours, eating granola bars from Target and being in a bathrobe. But maybe that's why she took toilet paper, because she knew she would have to be in the elements. So I don't know. It didn't seem that she was in the elements for 49 hours. But no hotel, I think, comes from the fact that there were reports and there was a call that she might have been at a Red Roof Inn. So I think that's why that's being addressed here.
My client apologizes for her actions to this community, the volunteers who were searching for her, to the Hoover Police Department and other agencies as well.
I'm going to keep going, but my client apologizes to the community, to law enforcement. I don't know if they go on to say she apologizes to family, but again, I see some of you saying, I think she was in the woods. She would not have been in great, she would have been covered in bug bites. Like, it is the South. It is a whole nother level. And if she was in the woods, there would have been a lot of, I don't think she was in the woods. Given the condition that she was in, or at least reported to be in when she returned, they said that she had a cut lip, but nothing else really. And if she had been covered in bug bites, they would have known that she had been outside.
As to her friends and family, we ask for your prayers for Carlee.
And friends and family.
Her issues.
She did say friends and family.
Attempts to move forward, understanding that she made a mistake in this matter. Carlee, again, ask for your forgiveness and prayers.
This is her attorney's statement admitting that this was made up. It does say that there was a mistake. I think based on the internet searches, this was not like she was driving down the road and then pulled over and then got out and wandered off into the woods. I think there was definitely more pre-planning in this. What I don't understand is why call 911? They're going to show up. And they did within like 5 minutes of that 911 call. So she called 911. She called her family. It was planned and staged. So planning and staging it was in fact a mistake. That shouldn't have been done, but it was a plan. It was a plan.
We have a meeting scheduled with Mr. Anthony to further discuss this case. We're currently in discussions with the Jefferson County District Attorney's Office in Bessemer about possible criminal charges related to this case, and we will announce those charges when and if they are filed.
So I think the next press conference we will hear is if and when there are criminal charges. The defense attorney will be meeting with law enforcement and probably wanting to meet with the DA as well. Criminal defense attorneys can meet with the DAs before charges are filed and say, can we negotiate what we're going to do? She'll plead guilty to a misdemeanor making a false police report, admit to the amount of restitution, do community service. If we can not do custody time, the defense attorney can provide more information to the DA saying, will you please consider this? These kinds of pre-filing conferences aren't unusual for those that have the money to hire a private defense attorney. It doesn't often happen if you don't hire a private defense attorney, because you as an individual can't go walk into the DA's office and be like, hey, can we have a chat before you file these charges against me? And if you don't hire a private attorney, you are not appointed an attorney until you are charged at arraignment. So she hired a private attorney, again, or her family did, has the means to do so. And that attorney will sit down with the DAs and give more information. Look, this is what happened. This is why, and explain more of it, and then ask for the charges to not be severe, and I imagine agree to restitution. But what I will say is, when you look at something like the Sherry Papini case, she was gone for substantially longer. She came home and took hundreds of thousands of dollars in victim assistance funds, saying that she was the victim of a kidnapping. She was gone for weeks and weeks. It was not a 2-day search. I don't know why this happened. I don't know why this was decided. But Carlee Russell ended this quickly by returning home. And in the scheme of all of the cases like this we have seen, came forward with an attorney very quickly. Sorry, I saw this comment about famous and the word stuck. Came in very quickly and said, okay, so look, there was no kidnapping. Faster than we've seen in other cases. So it probably didn't feel fast to her family and community, who for 48 hours thought that this was terrifying. But I think we will see that taking early responsibility, and in a criminal case, this is going to be considered taking early responsibility for one's actions by saying, yes, it is not the truth, will benefit her, and will benefit her in the charges that we see. And I think that they will consider that. With Sherry Papini, it went on and on and on. And the FBI sat down with Sherry Papini and was like, we know you lied about this, and we know you lied about that, and we know you lied about this. Now what? And she was like, no, I didn't. And then they were like, we're putting you in prison. With Jussie Smollett, it was, confronted with, again, the improbabilities. Why is there always food involved with him in the subway and all the things? And then he was like, no, I didn't. And they're like, we're going to trial. And he was convicted. And he's like, no, I didn't. In the scheme of other cases, this is a relatively short period of time where the attorney came forward and put out a statement to the public saying, we're sorry. There was never a kidnapping. This never happened. And I think they will attempt to use that to say she took early responsibility. She came back within 48 hours and solve it from there. The why of it all, we are still going to have to wonder. This is, even if the criminal consequences are restitution and things like that, the consequences within her community are still going to be consequences. Because now if you go to apply for a job or try to finish nursing school, everyone knows. And that is a hard thing. And the community feels burned. And if her parents didn't know, which during her disappearance, I don't think they did, I don't know how you navigate that terrifying breach of trust. And to play into the fact that so many women go missing, so many women of color go missing, and those are never solved. People are angry and frustrated. What I would hope for the future is that we see how much the internet can do if you know about a disappearance quickly and start asking for video. Start asking for it and hope that people are found. And if people lie about it, it will get sorted. This got sorted quickly. It will get sorted. But I hope we go in with find people when they go missing. And if they are not true, if what happened is not the truth, then they will be held accountable. And we saw that in Sherry Papini's case, and we will see how we see it here. I also hope that taking early responsibility shows that you can't just continue perpetrating the hoax. Because the other thing that's going to have to be dealt with in the community is the community frustration of how many taxpayer dollars were spent to go find someone who was not actually missing. Do you double down on that and spend more money to prosecute someone who said, you're right, I didn't do it? Or do you just negotiate that so you're not sending it through the court system and you deal with the restitution? Is that the appropriate response? I think that we will see them try to navigate that, because there can't be no consequence. But how much do you spend to further go down the road on this? So I think hopefully the takeaway is look how quickly the internet can find people when they look, and when they look quickly. And if that person is not telling the truth, that will also be found out. But if the internet can help find those that are missing, they should continue. And there are lots of organizations that do that. There are plenty of them. JB Bruno has been sharing on Twitter stories of people who are missing. These are stories that can be re-examined and hopefully will be. And I hope that we are having more conversations about how critical it is in those first 48 to 72 hours to have the news media pick up these stories. Most of us don't live in Alabama, but this story went international. And if that happens when there is a missing person, not just someone who's attractive, when there is a missing person, not just somebody who you're like, oh, their face will go well across all of our headlines, that the news can get these stories out to actually help find people, not just people who are attractive, people who are at risk. Find them. If they can amplify stories more quickly, there is more to say about people being found. So let's talk a little bit about, there was a GoFundMe. The family said they did not want a GoFundMe, and the page was taken down almost immediately. So we're not dealing with GoFundMe funds. What we're dealing with is Crime Stoppers. This is also coming from WFLA. Why? Because I have a tremendous amount of respect for their reporting. So, with that, let's continue. As Quilter, I did not mean that. I meant that people who are attractive get more news coverage, no matter what their race is. Does the media tend to pick up stories of missing white women more? Yes. But Carlee Russell is an attractive woman. It's part of why this story got picked up. Also, there was a 911 call. Also, there was the call about the scream heard by her brother's boyfriend. She is a very pretty woman, and that is a part of this. So no, I meant that she is attractive, but also the story was the type of story that the media picks up immediately. The media picks up people who they think will get clicks. And that is just what happens. The media has to pick up all stories. So I hope I made that clear. I didn't mean to not make that clear. So hopefully I made that clear, but the media does that. It absolutely does. And I think there's room to have conversations about the stories the media picks up and the stories the media doesn't pick up. Sherry Papini was an attractive woman. Carlee Russell is a beautiful young woman. So was Gabby Petito. It is very clear, but there are plenty that go missing that our society might not want to have conversations about, especially when we start talking about sex workers and others that go missing. It is not always the stories that the media want to pull up. Carlee Russell was a nursing student and had a job. There are things that play into how the media covers these stories and why some get picked up and some don't. And I think there's room for a conversation to say, if the media picked up more stories, I think people would rally behind them no matter what. But again, when the media sees something, they're like, this story will hit. And the media has control of that. The media has control of those narratives. Some of those stories we don't even hear about. They never get picked up. And I think there's room to ask questions about why. And I think lots within the media, and we're seeing this from independent reporters like JB Bruno, like Brian Enton, want to pick up those stories and want to make sure that those stories are run with. And I don't think the media should get to decide who is ideal and newsworthy. There, if that makes sense. I don't know how to fix that. I've never worked within media. I just do this. So it just is. All right. So hopefully I was clear, chat. It sounds like a lot of you know exactly what I meant. And GF made a good point. Media outlets are business entities. They don't want to carry stories unless it gets some viewerships, clicks, and helps their ad partners generate revenue. Those spots are sold during prime time for big money. I think so too. But I think there's room, especially when social media can have such far reach. I think there's room for these conversations to happen. I think so. So thank you all. We will continue on. Nishay said, I think you're being optimistic. I probably am being overly optimistic, but I think we can still push for it. And I think I have some of the bandwidth to push. And I think especially the Black community, the Native communities might not have the bandwidth to push. So I think those of us that do have the bandwidth to push can push and say, why aren't more stories being covered? And how do more stories get covered? And why aren't these stories being covered? Because that's how we can also help say, how do we get these stories picked up and covered more? That's the question I'm asking. And I think it's a question we're seeing others in media ask as well. And I appreciate that. I appreciate that others in media are asking that as well. So we have room to push. And for those of us that have the bandwidth to do it, we can push. So Rob said tons of room. Every media outlet is on all social media. It doesn't always have to be a broadcast. I agree. All of them. They're on TikToks. There's room for it on Twitter, on Threads, on Mastodon, on whatever other social media. There's tons of social medias. I think there's room. So let's take a look at the money, shall we? We need to talk. You know, my theory is follow the money, right? Follow the money. So let's take a look at what happened with Crime Stoppers. For those of you not familiar with Crime Stoppers allows you to donate somebody said it's not Twitter anymore. Damn it. I have not gotten a personal letter. I don't know what to do with that. And I'm just not, I don't know what to do with that. I don't know what to do with Twitter going to like X or whatever. I don't know. I don't know what to do with that. So, anyway, let's talk about the money. For those of you not familiar with Crime Stoppers allows people to donate money that can be used as reward money. So when we saw at the beginning of this, they were immediately offering reward money, saying, $63,000 for information leading to her being found or brought home safe. So with Crime Stoppers, that is part of what it is for. The money is raised to go to help incentivize people to come forward with information that leads to more information. So let's, can we get an explanation? I don't know if we're going to get an explanation about this case. If there are charges brought, we might end up more. This is from WFLA. I'm going to see if we can do this without, and just in reader view. Reward money raised in Carlee Russell case won't be refunded unless donors ask. Alabama woman Carlee Russell vanished after she reported seeing a child walking alongside the highway last week. Donations began to pour in to assist her safe recovery. Crime Stoppers of Metro Alabama raised more than $63,000 in reward money in less than 2 days, right? This was instantaneous to help find Russell before the 25-year-old returned home shortly thereafter. According to the Birmingham News, the organization initially said it would return the $63,378 to donors. Later that same day, the Bob Corpus There's not an R there. Copus, the organization's executive director, said some of the donations had already been returned. One was a $25,000 donation from the Birmingham Board of Realtors and a $20,000 donation from an anonymous donor. So $40,000 in donations in 2 donations. Hours later, the organization reversed its statement, telling the news outlet the remaining money would not be returned to donors. The investigation is still ongoing, and accordingly, there is no basis to refund any contributions at this time. Furthermore, Hoover PD has not requested for any donor contributions to be released or refunded. About 60 donors pledged over $13,000 through a PayPal link set up by Crime Stoppers. Quote, for large donations, we have an agreement that said you're giving us this money for this specific case to be used if law enforcement officials deem they're going to use the money for a payout, and that's for rewards for a tip. If it's not used or the case is never solved, you can have your money back. The organization said it was reaching out to donors to let them know they can get a refund if they choose. We would never use a crime as a fundraiser, Copus said. This is strictly for the benefit of getting law enforcement the best information as quickly as possible, and also it allows the public to get involved because they want to get involved. Russell, who was a nursing student, vanished after she got off work on July 13th and claimed to have seen a child walking along I-459 in Hoover, Alabama. When police arrived where Russell was last seen, she was nowhere to be found, prompting police to declare her missing. A widespread search to find her was conducted shortly thereafter. Around 48 hours after Russell vanished, she reappeared on July 15th. Her family members told police she had walked home. When she was taken to the hospital for treatment, she told officers she had been abducted. So it sounds like Crime Stoppers will refund money if asked. So Crime Stoppers, if you donated to Crime Stoppers and want the money back, it sounds like you just need to request it, but they are not proactively just sending back the donations. But there's not going to be like bulk refunds. So with that, if you did donate and want to reach out to them, it sounds like you can. And that is something that you can do. So the GoFundMe was taken down early. Crime Stoppers said that it will refund money if asked. So I know the headliners or the headlines shout won't be refunded, but it will be refunded if donors ask, so they can. Shall we talk about the TikTok defamation case? Are y'all ready to talk about the TikTok defamation case? Brittany asked in the chat, has it been released why she did this? There has been no explanation. There has been it didn't happen statement that we went over the press conference, but there has not been anything else that has happened. So, Crystal said, so Crime Stoppers only refunds your money automatically if you can afford to donate thousands. Just refund the money without people having to reach out. They are not going to do that. So with this, could we see criminal charges brought? Yes. Do I think something will happen from here criminal charge wise? Yes. Do I think that will probably be negotiated with the defense attorney, and what we will see is that there is a charges and probably a plea agreement at the same time? Probably. I think that will probably happen. I don't think a defense attorney makes admissions in a approved release statement if there's no other way around it, because there is no other way around this. We know how much law enforcement knew. We know there was no other way around this, and I think that is that's the defense attorney trying to do what is best for their client by taking responsibility early in a public way, by apologizing, and then being able to go to the something weird's happening in Idaho, to the public and saying we've admitted responsibility early on. All right, let's look at this real quick. I was just looking, we're moving to Idaho for the rest of the stream. Let's move to Idaho. Thank you for having a conversation with me about it. I know so many of you are frustrated with the Carlee Russell case. So many of you are frustrated. I completely understand. There are many that go missing and never are found, never return home, and whose families never have closure. It is heartbreaking. And I think everyone, well, or at least what I saw, is people were rooting for her. I saw Natalie Lawyer Chick play the clip of Tyra Banks being like, we were all rooting for you. I think a lot of people felt that way. We were all rooting for you. And people were so relieved when she was found. And then to have it unravel later is frustrating. And I understand that. I understand the emotions there for sure. All right. Let's see. This is the case docket in Idaho. There's a whole bunch of things missing from like 7/12, but there were updates after that, but I don't know where they all went. So I don't know why documents are coming down. Or if this is just a website error in the Kohberger case, but that's something I'm going to be keeping an eye on. Let me go download the update. This was updated on the 13th. I thought yesterday there was a newer update. So I wonder if they are backtracking things. Let's see, because this has all the stuff from the 12th, the motions, the supplemental response, other motions, an order. Interesting that some of that stuff is now down. All right, we're going to just save that real quick. Let's go talk about the defamation case. Let me pull up my notes from that case and we will move on. All right, are you ready? Are you ready? Are you ready? I'm ready. I have like 4 pages of notes. Apologies. I swooped to that part, but I'm going to swoop to this part too. Let's talk defamation, shall we? Oh, this defamation case. This defamation case, y'all. This one. Yikes. All right. Here's what's going on. In Idaho, a TikToker who was a spiritual witness, they say, to the murder of the 4 victims in this case, accused a history professor at the University of Idaho of planning and executing the murders and of having an affair with one of the students. I was going to say inappropriate, but it kind of like an affair with one of the students kind of already signifies to you that is inappropriate. So there has been a lot of litigation in this case. The university professor has made a motion to dismiss and a motion to quash. The motion to quash is regarding the fact that the lawyers have all been, improperly joined into this lawsuit. So, professor sues TikToker for defamation. TikToker cross-claims, countersues professor, and adds all the lawyers. And the lawyers are not original parties to the case. Did not get leave from the court for a third-party joinder of the lawyers and is trying to sue the lawyers for suing her for violating her First Amendment right to freely practice her religion, among other things. So there are 11 counterclaims against the professor and the lawyers, including conspiracy, including violations of civil rights and others. I've gone thoroughly and repeatedly, it feels like, over the cross complaint because it was a lot. It was a lot. So the attorneys are seeking to dismiss the counterclaim complaint from the TikToker against the professor. And they are seeking to quash the subpoena against the lawyers. They're not seeking to dismiss the counterclaim against the lawyers because they're saying the lawyers have not been properly brought into the lawsuit. So a motion to quash so that the lawyers can't be drawn into the lawsuit, and the motion to dismiss the 12 counts against the professor, the counterclaims. So that was the posture of the case when it came before the court for hearing via Zoom on the 21st of July. At the exact same time, I was also trying to buy BravoCon tickets. the court gave each side 20 minutes and gave Attorney Olson, because Attorney Olson has the burden on these motions, gave Attorney Olson the floor first, then went to the TikToker Gouliard, then let Olson close. Then the court had a few statements at the end. So I'm going to go through my notes and what happened at this hearing. The hearing can't be recorded, distributed, or anything like that. But every time the TikToker has been before the court, whether in writing or in this hearing representing herself, the TikToker has said, basically, I said what I said, I mean what I mean, and you can't do this. The court has not issued a ruling yet, though I expect that we will see that this week at some point. I think it is likely that the court will grant the motion to dismiss and the motion to quash, but they have not done that yet. Could the court allow for amendment? Yes. But Olson is asking that this be dismissed with prejudice, meaning it can't be brought again. So everybody was present. The TikToker represented herself. The opening statement by Attorney Olson, and remember, Attorney Olson, we've seen in court in the Idaho case, because Attorney Olson also represents the Media Coalition. So Attorney Olson represents the Media Coalition fighting for access in the courtroom that took this up on appeal and is representing the professor in this case. So we've seen Attorney Olson more than once. We know that Attorney Olson is a former U.S. prosecutor. So Attorney Olson reminded the court that the professor was in Portland at a wedding at the time that this happened, talked about the other lawsuit where Gouliard is being sued, stated that all of the assertions and counterclaims made by the TikToker are based on conjecture, that they are unsupported conclusory allegations, that the TikToker did not seek joinder. Joinder means that you're properly allowed to bring in other parties. Counterclaims me if Cardi B sues Cardi A. We were talking about this last time. So if Party A sues Party B can sue Party A, or Cardi A can sue Cardi B, or Cardi B can sue Cardi A. But if Party A sues Party B, and then Party B wants to sue parties A, C, D, and E, you have to join C, D, and E because they're not already there. You only have the first two. You have to ask the court, hey, Your Honor, can I bring in all the rest of these peeps? We need them too. We saw Murdaugh making allusions to this in the Satterfield case, where Murdaugh was like, oh, insurance company. Well, in the insurance company case regarding the Satterfield settlement, oh, insurance company, if you want to come after me, you also need to come after them. You should join all of them. Join all of them in. So Lindsay, that's the joke. Lindsay in the chat said, I know you are saying Cartier, but I keep hearing Cartier. Yeah, that was the joke from last week. I'm going to keep reusing it because I kept saying Party A and Party B, and somebody in the chat said, so if Cartier or if Cardi B sues Cartier, where do we get instead of Party A and Party B? And I thought it was hilarious, and I'm going to just keep going with that. That is the joke. If Cartier sues Cardi B, then what happens? Or if Cardi B sues Cartier. But it's just a funny way of saying Party 1 and Party 2 or Party A and Party B. The thing is, if 1 and 2 are suing each other, you can't bring in 3, 4, and 5 without leave from the court. And that's what the TikToker sought to do here without asking for joinder. And it's what happened when we get back to the legal, and not the haha part of it, but when we get back to the legal part of it, that's what Murdaugh is trying to do in that, or force someone else to do in the insurance case, saying, hey, insurance company, if you're going after me, you can't go after me without joining in the Satterfield sons and their attorneys and stuff. And we're like, ugh, he can't make the motion for joinder, but he's trying to push the insurance company to make that motion for joinder. So it really is just joining the parties. And the lawyers for the professor said the defendant did not seek joinder from the court, which means you would have to ask the court to bring these parties in. And then you have to prove to the court why the parties should be brought in, which isn't going to happen here because you can't sue lawyers for suing you in this circumstance. They're doing their job. So the counterclaim, they argue, doesn't allow her to add the lawyers as co-defendants. And then the court interjected and asked, but Gouliard says that she just said it wrong, that she said cross claimants or cross defendants, and she meant third-party defendants. So can she just bring in third-party defendants? And that was addressed by Schofield's attorneys, and they were like, you still have to have the court's permission, and there is no court permission here. So then before it's Gouliard's turn to speak, the court said, I need you to just address the points. And the court then gives some guidance. The court was very patient. We've seen a lot of patience from the court. The court was very patient and spent their time kind of describing what was going on to TikToker and narrowing down the argument. Like, can you just address this part? And so instead of letting her spend 15 minutes kind of making a general statement, the court really asked the TikToker to narrow it down and address certain points in a very patient way that I think made a very good record, because the record is now very thorough and very well kind of meted out. So the court, when the court makes their ruling, especially if the court denies or grants these motions, which would kick out these claims, the court has a very clean record to go through. So the court said that case law requires factual allegation raised to rise beyond the level of speculation. So the court asked the TikToker, how do you respond to the plaintiff that your spiritual research does not survive the basic pleading standard of rising beyond mere speculation? So Gouliard, and at this point I am typing at warp speed. Gouliard said, as the court decides that it's not plausible, that her statements are not plausible, that it puts her, quote, it puts her religious practice in a position to be refuted as truth or refuted as plausible, and it puts the court in a position opposite to the First Amendment. So she came right out and said, if you decide that my spiritual witnessing is speculation, the court is denying me my First Amendment right to freedom of religion. And that is how this hearing went. She then said, which I think we are going to see, I believe what I said to be fact. They are choosing to say that it's not fact. She said, they are choosing to say it's not a fact because it came from my spiritual investigation. If we get to discovery, I can quote, this is a direct quote, if we have discovery, I can find facts to support it. You can't use discovery as a fishing expedition. You have to have like a reasonable belief that there's evidentiary support for your claims before you make the claims. You can't just make a claim to get to discovery and try to root around and find something that might make it stick. That's not what discovery is for. You have to have some basis in something that goes beyond mere speculation. But here's the thing. If this is dismissed, it could be the fact, I don't think so, but it could be the fact that she still gets to discovery because she's not going to settle the case against her. So she's entitled to discovery because the professor is suing her for her TikToks. So she will get discovery and she can wait and sue when she has like evidentiary support. I don't know if she'll find evidentiary support to these claims. I would suspect that she wouldn't. And if she does, then there's a lot. And then there's a lot of questions if there's support to the fact that the professor did this. But she is pinning a lot of this on a First Amendment freedom of speech and freedom of religion argument. That if the court says that her bare assertions are not plausible, that somehow that is the court attacking her spirituality. I don't think the court is going to see it that way because, well, We'll get to the example given by the plaintiff's attorney later on. Emily, don't jump ahead. Don't jump ahead. Go in order. Go in order. We're going in order. We're going in order. We're going in order. We're going in order. The court then cuts in and says, and then the court started doing this. The court cuts in and says that plaintiff's point is that what you have alleged is not corroborated with objective facts. Y'all are asking for Audacity Green. Do we just go to Audacity Green? People are saying it should be Party C, should be Cardi O. Cardi A, Cardi B, and Cardi O. I like it. Should we just? We can go Audacity Green. We can go Audacity Green. We'll have to make a bumper for Audacity Green. We're not at a bumper for Audacity Green yet, but hold on. Let's take a minute and we'll get to Audacity Green. Hold on. Did I save it? No. Emily, what a fail. Hold on. We'll go here. We'll make this a little less blue in the back, and then I'll save it next time. We're getting there. We're doing it. We're doing it manually. Go to green. Code green. The audacity of it all. There, I think we've reached Audacity Green. It's not the best shade. It's a chartreuse, perhaps. We've reached DEFCON. What the audacity? There we are. Miguelina will have to do an Audacity bumper. I'll have to save it and make an Audacity complication so that we can do this. Hold on. I need to move this light back to not Audacity Green because it's going to start making me look green. And that's, I'm triggered for when I was very blonde in high school and swam all the time. My hair had a faint hue of green. Chlorine. If it can change your hair colors, it's probably not healthy for you. All right. Audacity Green. Let's continue on. So the court was like, yo. What they've said is that what you say is not corroborated by objective facts. It's belief. The court said it's not corroborated with objective facts. It's belief. He said it may be your genuine belief, but no objective facts. Are there any objective facts to support your claim? The court just went point blank. What are the facts? Are you ready for the response? The TikToker told the court she's a professor and the victims are students. She also said it's happened before that a professor has caused the murder of an Idaho student. And the court was like, wait, what? The court goes, what are you referring to? Because the court was not having it at all. The court goes, wait, what? Direct quote, it's happened before that a professor has caused the murder of an Idaho student. The court's response. And the court said, what are you referring to? In a very, very serious tone. The response was, well, I'd have to look it up again. Wait for it. Wait for it. Wait for the direct. Wait for it. I have never been more thankful to Mavis Beacon teaches typing than I was in this moment because the rapidness with which I took notes. The TikToker said, I would have to look it up again. I didn't foresee that question being asked. It was not foreseen. Those were the exact words. I did not foresee that question would be asked. I'm sitting here listening to this court hearing going, those were Those were the words that were chosen. Those were the words that were chosen. The chat's like, you had one job. One job. Didn't anyone tell you that this was going to be asked? Anyway, the way that she said, I didn't foresee that question being asked, just hit different. It just hit different. I guess she did not foresee that question. She then goes on to say, it's possible that she knew the students. It's possible. And the objective fact is that she worked at the university. So she has alleged that a professor at the university has caused the murder of 4 students, had an affair with one of the students, and has continued on to say that she is a spiritual witness to this crime and that she is guided through her spiritual research, but that the only objective fact is that the professor works at the university. That's what she told the court, and that's why it's going to get dismissed. Because that is the only evidentiary fact that she has, is that this professor was on the website for the history department and was to be discussed. Don't worry, we keep going. The court then interrupted and said, plaintiff's point is that to sustain a pleading, it has to rise beyond possibility or speculation. There must be objective facts to support your subjective belief as to what happened. There must be objective facts to support your subjective belief. And she said that doesn't align with why they sued me. She said there are no facts. They have no claim against me either. They sued me saying that I stated facts against the professor that they are arguing aren't facts. So then she tried to spin it, saying that they don't believe the facts. And because they're saying that, she was trying to say to the court, well, what the professor's saying that I say are facts are not facts. So how can they sue me saying that they're not facts? Because you're telling me there have to be facts. And what I'm telling you is, Your Honor, they're arguing a defamation claim that what I said aren't facts. And so if what I said aren't facts, then they also don't have facts. And I'm sitting here going, okay, so the fact, she is not seeing the facts in the defamation case. She's seeing the truth of what she said being the fact, not seeing the fact of what she argued. Right. Y'all are like, wait, what? Right. So she is arguing that because they are saying that the facts aren't true in the defamation case, that those facts shouldn't be allowed to stand. So that is what's happening. The court then cut in and said there are 2 different things, and we're not arguing their complaint. We're arguing the motions on the table today. We're just going to talk about those. And then the court decided to take the reins and say, okay, we're going to go thing by thing. And if we go thing by thing, that's how we're going to get through this. And that's where the court ended up with, like, we're going to go thing by thing. So the court then asked, okay, count 1 and 2 to the defamation claim, that no such cause of action under the statute. The statements made by lawyers are absolutely privileged and cannot be based on this type of claim. I know you're not a lawyer. I'm giving you every benefit of the doubt, but I'm trying to understand your arguments. And she said I was referring to Idaho state law, and the court and her went back and forth. And the court said then, how do you respond to the argument that simply making statements to the press and filing a lawsuit is not covered by litigation privilege? The TikToker responded to the court that the comments in the media weren't made on behalf of Professor Schofield. This is an interesting argument. Look, there were arguments here that made complete linear sense. It's not, I don't think it's going to fly, but I can see where it made sense to her that she is arguing that the statements made to the media weren't on behalf of the client. I disagree with that. I think the court's going to disagree with that. But she's saying those are false statements of fact made by the attorney Olson on her own for her own benefit, not as a representative of her client. And then she started to argue defense to the defamation claim in her case. It just shifted. And she said that those statements caused that the statements were made on behalf of the attorney, not on behalf of the client. She then started arguing that Schofield grew in popularity because of the statements made against the TikToker, and that the attorney is fighting this outside of court, and that's not protected by litigation privilege, because she was fighting it in the court of public opinion, is what she argued. Responding to media inquiries about a lawsuit is not going to fly because the person who put this, lawyers are allowed to respond to statements made about their clients to correct the record under pretrial publicity rules in most states. And we know more about pretrial publicity rules in Idaho than most states because we've covered it over and over and over again. So the person who caused Olson to make the statements in the first place is the TikToker by making statements that they assert are false against the professor. The attorney's allowed to correct the record. So the court interrupted and said, what about claims 3 and 4 of conspiracy? And then the court explains the plaintiff's argument again and asks for response. And the court then does this with every single grouping of claims, saying, the plaintiff's arguing this, how do you respond? And so the court kept the arguments pretty tight so that there's a clean record, and I appreciate that. The entire argument, the TikToker says to the court, is that my spiritual practice and beliefs are fantasy beliefs, and they, the plaintiff, has disrespected and alleged that it's fanciful or made up. They targeted me as a spiritual practitioner. If I made these allegations for other reasons, like I saw her, then they couldn't argue this. I am being targeted because of my religion and spiritual practice. The part of that I got stuck on was, if they made these allegations up for other reasons, like I saw her, then they couldn't argue this. Ma'am, if you saw it, that's very, very different. If you were a percipient witness to a thing, that is a very different thing. But they're not targeting you because of anything other than what you said. And they're not targeting you, they're defending. They're on the defense because you went on the offense on TikTok to say the things about the professor, not being targeted. The court said, I understand your argument. The court said this a lot. This was the court's bridging phrase when the court interrupted. I understand your argument, but they're also arguing this. They argued immunity for 1985 claims because they're representing their clients. We're not going to get deep into it, but she said, no, that's not what immunity's for. They're using immunity to discriminate against me. That's not the use of immunity. And the court was like, we're just moving on. And then the court said, wouldn't that apply to every defamation case? You believe there's not a basis in truth according to you. But aren't you saying that everyone that files a defamation suit can be sued? If any lawyer can be sued for, like, I'm suing you because you're suing me, doesn't that apply everywhere? And the TikToker said, no, they're targeting me based on my spiritual practice. They don't have an argument for defamation against me because I believe my statements are true. They say my statements are fanciful to target me and to meet the elements. The court said, they pled that what you said isn't true. I don't understand what you are arguing about your statements. They've alleged the elements of a defamation claim. You're saying it's substantially true, which is your affirmative defense, but that's your argument that they haven't met the elements. And then the TikToker kind of steps over the court and says, Rebecca knows what I said about her is true. Now, the professor and her lawyers are on this call. So the TikToker is now also on the Zoom call saying, and of course the audience can only have audio. I'm so glad there was audio that we could listen to. She said, Rebecca knows what I said about her is true. The attorneys don't know that I know what I said is false. So she starts arguing that the attorneys can't argue that what she said was defamatory because the attorneys have no basis in knowledge to know that what the TikToker said that she believes is false. What the court never got into was defamation per se. I'm not getting into it today either. We're not going to open a can of worms. She continues to call the plaintiff by her first name and said, they mock my spiritual practice. Rebecca did it, and she knows what I said is true because she did it. Then the court said, okay, but the plaintiff argues that you can't have a 1983 claim under color of law to support the 1985 civil rights action. And she said they used the state law to conjure up a cause of action against me. That's not how that works. That is not going to fly. The court then goes on to the malicious prosecution response and says, look, plaintiff's argument is that malicious prosecution claims can only be brought after a case is terminated. The case has to be done and complete before you can bring a malicious prosecution claim, because that's the law. The TikToker said to the court, I put it in there because if they win any of these claims against me, it's a frivolous claim, so we might as well argue it all at the same time. She's like, Your Honor, I am trying to save judicial economy, was essentially her argument. Why don't we just do it all at once? Wouldn't it be better if we all do a triple? Was her argument to the court. She didn't have much else to say about that other than we should just do it all at the same time because it could be down the road. And the court was like, so you're saying it's Let me just read what the court said. So the court said, so you're saying that it might be terminated, so we should just do it at the same time. Okay. And then the court said, as to counts 10 and 11, the IIED claim, plaintiff's argument is that under Idaho case law, the simple filing of a lawsuit does not rise to extreme and outrageous conduct to support a claim for IIED. We've talked a lot about this. We know that IIED has to have extreme and outrageous conduct. We've seen arguments in Florida in the Laundry Petito case between the parents over what is extreme and outrageous conduct. We've seen arguments from attorney Steve Bertolino that making statements at a press conference isn't going to rise to the level of extreme and outrageous conduct. We've seen Gabby Petito's parents argue that under case law, particularly parents of murdered children are particularly vulnerable under the law. And so statements can be extreme and outrageous. So we're in this realm of like, how do we define an extreme and outrageous? And case law says filing a lawsuit is not extreme and outrageous. That's done. But wait, there's more. So the TikToker says this is not the simple filing of a lawsuit. This is a frivolous and unnecessary lawsuit. And she did the things in the lawsuit. And then she goes into no damage. She didn't lose her job or her family. She gained money through her GoFundMe. And then the court cuts her off and said, but isn't the GoFundMe for legal costs? And the TikToker goes, my argument is that she's popular enough and she's receiving support. Popular. You all asked. You asked about defying gravity, which is not happening. But I feel like popular is coming up because the argument was then that the professor is popular. So then she said that she's popular enough, she's receiving support, and there's no reason to file a lawsuit to make my opinion unbelievable, to assassinate my character. And the reaction she said she'd received at the court is harassment, threats, death threats. Her connections on social media have been terminated. The lawsuit is frivolous and unnecessary, and it doesn't meet the elements. And they spoke to the media. And that, she argues, makes it extreme and outrageous. Extreme and outrageous. So then the court says, you say the filing was unnecessary. At this point, I am like, hello, Judge Patience. Hello. The court says, you say that this filing was unnecessary, but do you see how, from her perspective, being called a murderer and being alleged to have an affair with a student might justify a defamation lawsuit? The court got all the way to the point. Do you see how, from the other side, just perhaps, there's a perspective here? The TikToker responded, I understand it can make a person angry. Let's just say I made a mistake and what I said isn't true. I can see that she would be angry, but she doesn't have a cause of action against me. She didn't lose her job. She didn't lose money. She didn't lose family. That is an argument against the defamation claim that there's no damages. So she's trying to argue there's no damages to the defamation claim. We're not going to talk about defamation per se. Just keep that in the back of your mind. So she's arguing that there's no damage to her. So the lawsuit's frivolous because you're not harmed. Defamation lawsuits are about harm of reputation, right? She said, they said she lost sleep, Your Honor. That doesn't justify a lawsuit. Nobody knows me where she works. It's my opinion, and it didn't hurt her at all. She goes on to say this entire case is unnecessary, and the reason she lost sleep, hold on to your butts, the reason she lost sleep is because she did all the things. She can be angry, but it doesn't give her a cause of action for defamation. That is her argument to the court. She is losing sleep, not because of the claims, but because she knows she did it. And that makes this lawsuit outrageous. I think the court's probably going to grant these motions. I just want to see what the court says when they grant the motions. The court said, is there anything else you would like to say? The court was like, I thought it was also interesting that at that point she said, it's my opinion. And she did say, let's just say I made a mistake. She then clarified that she didn't make a mistake and that the professor did this. Anything else you want to say? Yes, Your Honor, the motion to quash. They're using the motion to quash as a motion to dismiss the summons issue properly. I added them as joiner of claims. She didn't say joinder. She's not a lawyer, but I think she is trying to defend this lawsuit. She is not just not trying to defend the lawsuit. She is trying to defend this lawsuit as a pro per. She probably needs a lawyer to sit down and say, this is not going to go well. And you could end up being responsible for a lot of money here. She said it's not a proper motion to quash because I added them in my answer. And the court said to clarify, she's arguing that they aren't opposing parties. Thus, your counterclaim against the lawyers is improperly added. She said, I was following the guidance of their argument. So she's trying to, it seemed like when the plaintiffs respond to things, she is trying to take what the plaintiffs said and then fix it. Like she's using the plaintiff's arguments against her, literally, she said, as guidance. The opposing parties are not there to guide you. Ask your lawyer. You could end up spending more money in paying their lawyer's fees than paying your lawyer's fees. But the court was incredibly patient. She then started arguing with the court about whether they can be joined without leave of court under the rules. And the court said, again, but you understand that the lawyers are not opposing parties, so the rule that she was arguing is not the correct vehicle. And she goes, no, but I changed it. I changed it to third parties. They're liable for the counterclaims. They're separate claims. The court said, I appreciate your efforts. Thank you for that. Is there anything further? And then the court said, okay, no, she's done. She must have just shaken her head or something. And the court then gave Attorney Olson an opportunity for rebuttal. Attorney Olson says she continues to use this litigation to defame Professor Schofield. She has shown no regard for truth, career, reputation, and humanity. She tries to say that her factual allegations are plausible. She argues that she wants to prove that in discovery. The counterclaims have no basis in fact and should be dismissed. She articulated no objective facts. The objective fact was that the professor is a professor at the university. She has tried to address the claims against her, saying that there was nothing there that she said that involved anything about the professor, so the whole thing should be dismissed. She argued that she was targeted. That's not it. They tried to get this is me saying they tried. The attorneys argue, we tried to get Gouliard to stop. She repeatedly proceeded. She didn't stop. And they talk about the amount of reach out they did to the TikToker saying, this is false. Here's the cease and desist. They tried to get her to stop repeatedly and she didn't. They're like, we're not targeting her. We tried. We failed. They said the lawsuit was filed because she continued to make statements on TikTok against the professor. Respect to spirituality and her ability to practice her spirituality. This isn't about tarot cards or psychic abilities. She can't use it to defame people on TikTok or in any other medium. And then she got into animal sacrifice. There's actually case law about this, but saying, look, whether you have the right to practice something as a part of your religion, she used the animal sacrifice example, you can't go and sacrifice your neighbor's dog. If you're claiming that that's part of your spiritual practice, you can't impose that on somebody else. They go on and argue she has brought frivolous counterclaims against them. They should be dismissed with prejudice, award attorney's fees. And she said, we are now dealing with a whack-a-mole situation and the court needs to stop allowing different things to pop up. What's supposed to happen in litigation practice is that somebody files a motion, there's an opposition, and then the reply just goes to the opposition, things that weren't brought up. The TikToker keeps changing arguments in the middle of litigation practice in a way that you normally can't bring up. You can't bring up new arguments in the subsequent pleadings. And that's where we're getting this, like, Your Honor, she keeps shifting gears because, well, she is not an attorney and she does not know. They didn't say that. They said, we are playing whack-a-mole with these arguments, and the court has an important gatekeeping function, which goes to the joinder argument. The court is supposed to evaluate the claims before they allow other parties to just be dragged into endless litigation. The court says, thank you to everyone. I appreciate the argument and the motion practice. I'm going to try to have an order up as quickly as possible so we can keep the lawsuit moving. We will get that to you in short order. The hearing was about an hour, a little over an hour long. I think the court did a really good job of trying to pin down the arguments from the TikToker so that there was a broad, like a vast and broad record of the fact that there is nothing more than speculation here. And that's what the court is trying to say. We need objective facts to support your subjective belief. What are those objective facts? And the TikToker was, she could have known them. And that's what's going to go down the road, right? So I keep looking for the court to make this ruling. I think the motions will probably be granted. I think the cross complaint will be dismissed. Whether it will be dismissed with prejudice or not, we will see. What I think the motion to quash will be granted. And then I expect if the motion to quash is granted, that the TikToker is going to file a motion for joinder. I think the court will deny that motion for joinder. You can't sue the lawyers for it, but it's a wild case. But the TikToker has kind of foreshadowed what her arguments will be if this goes to trial. If this goes to trial, Mia said, Linda, listen, you need to stop. If this goes to trial, her argument is going to be, these are not false statements. I believe it. That is going to be the argument. I believe these statements. So with all of that, a lot of you have asked why the court doesn't just yeet these things immediately. The court does not yeet these things immediately because there is a process for it. And everyone has the right to their claims being evaluated by that process. And that's what's happening here. The court is evaluating process, and the court is allowing for due process and evaluating the claims. But what's difficult is that it's going to cost the professor a lot of money to deal with it. Right? So, I saw some of you ask question. The next person on the right said, question, is that a legit defense? I believe it, so it can't be false, lies, and defamation. If malice is required, and I think there's an argument that this professor is not a public figure, so malice is not required, you have to prove that they should know that it's false. They either know or should know when we get to that malice element. I don't think we're going to need to get to the malice evident. So as I was refreshing Pacer, y'all are going to have to stick with me. We're going to do 5 more minutes, and then we're going to get to questions real quick, but there's a new filing in Idaho. So as I was refreshing, because the website in Idaho had been down earlier today, there is a new filing in the Idaho case, which was due yesterday, which is the notice of defendant's response to the state's alibi demand. This is a quick 2-page document. So let's go over. This was filed yesterday at 5:02 p.m. This just popped up on the website at some point while I was live because it was not up there earlier. So let's swoop and go to Brian Kohberger's alibi, shall we? All right, let's pull this up and go to the notice of alibi. This is a first look. I haven't seen this. So let's talk. This was due yesterday. I'm sorry if the bumper scared you. Some of you love the bumper. Some of you were like, what is happening? So this is filed by Brian Kohberger's attorneys. Notice of defendant's response to state's alibi demand. This was due yesterday. Comes now, Brian Kohberger, by and through his attorney of record, hereby files notice in response to the demand for alibi in compliance with Idaho Code 19519. Kohberger notes that Idaho Code preserves its constitutional right to silence as well as to testify on its own behalf. Kohberger stands firm on his constitutional right as well as the statutory recognition of that right. Noteworthy is that an alibi indicates a line of proof by which the defendant attempts to show that he could not have committed the crime of which he is accused because he was elsewhere at the time. A defendant's denial of charges against him does not constitute an alibi, but as soon as he offers evidence that he was at some place other than where the crime was committed, than where the crime of which he is charged was committed, he is raising an alibi defense. Mr. Kohberger's defense team continues investigating and preparing his case. Evidence corroborating Mr. Kohberger being at a location other than King Road will be disclosed pursuant to discovery and evidentiary rules as well as statutory requirements. It is anticipated this evidence may be offered by way of cross-examination of witnesses produced by the state as well as calling expert witnesses. So they are either trying to use technological evidence that they don't have yet, but they were required to turn over any alibi defense by yesterday. And so it seems that the alibi defense is, hey, evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discover and evidentiary rules. If it exists, is what I'm reading with this. So they think that this will come by the way of cross-examination of witnesses. I don't know what witnesses they think they're cross-examining, but they are telling the state, you already have the witnesses that we're going to rely on for our alibi. So this is a disclosure under alibi saying we will turn it over as we are required to. They were required to give notice of alibi defense. Their notice of alibi defense is, so yeah, that's we don't really have much. We might call an expert. If they're going to call an expert, they're going to have to turn that over. But this feels like we continue to investigate and prepare the case that they don't have an alibi defense at this time, and that any evidence they need to disclose will be disclosed. They were required to turn it over today. So if they bring in another witness, it's going to be too late. We will see what the state has to say about that, but this is not a lot of evidence. We'll see what comes after this, but they had to turn over notice of alibi. Their notice of alibi is, we're continuing to investigate, and evidence corroborating Kohberger being at a location other than King Road will be disclosed. I mean, I'm reading that as an if, but maybe they have evidence corroborating that Kohberger is at another location, but wouldn't it be their witnesses? They anticipate this evidence offered by cross-examination and an expert. If they have a tech expert that's going to show they're somewhere else, they need to turn that over. So we'll see. But they need corroborating evidence. It sounds like they're going to cross-examine witnesses, and they don't have much else to corroborate it. So that's what it is. They will turn it over. Evidence corroborating him being at another location will be disclosed. This was what they were going to disclose. But by the fact that they think it's by cross-examination tells me that they don't have affirmative witnesses except perhaps an expert, and that expert will probably be a tech expert. And that tech expert will attack the cell phone pings, show new cell phone pings. We'll see. We'll see what happens. But they're like, hey, we're not bringing in necessarily alibi witnesses. We're going to cross-examine your witnesses, and we're going to call an expert. That expert will have to be disclosed in discovery, and that will probably be sealed. And that will probably be I imagine that'll be a cell phone tech expert to show where the pings of the phone are, or to show how big the radius is in that area and things like that. So they don't have any, it sounds like, other than potentially an expert witness, they don't have any specific alibi witnesses that are saying, I was with Brian Kohberger. So that's their alibi disclosure that was due yesterday. That's not, discovery is ongoing. So it's not I don't think it's a huge deal. We'll see. Maybe some will think it's a huge deal. It's just Candy7 in the chat asks, what if he was home sleeping? How would they prove that? Through tech evidence, through evidence at home, through video showing the car being there, things like that. That's how they would try to show that, but that's maybe not. I mean, that would be them showing that they don't have enough, arguing that the state doesn't have enough, which is really what it is here. Our alibi is going to be cross-examining your witnesses, showing that it's possible that the defendant wasn't there, or the defendant was still at home. And a lot of you are asking, why couldn't he say, I've seen this question a couple times from Doodlebug, why couldn't he just say I was at home sleeping? Because then he would have to testify. And he has the absolute right not to testify. So to say he was home sleeping, he would have to testify. And that once you can't just waive your Fifth Amendment right to say the one thing, because then you're open to cross-examination by the state extensively. So he can't just say, there has to be other evidence to say it, unless he is going to choose to testify. He has the right to not testify. And they remind the general public of that early in this, right? That, where is it? Idaho Code reserves his constitutional right to silence as well as to testify on his own behalf. So if the defendant's going to testify, that's different, right? That doesn't have to be provided. Kohberger stands firm on his constitutional right as well as statutory recognition of that right. He doesn't have to testify. And he can't be forced to tell you what he would say if he would testify. So an alibi indicates a line of proof by which the defendant attempts to show he could not have committed the crime of which he is accused because he was elsewhere at the time. Like Professor Schofield saying, I was in Portland, Oregon. I think Portland, Oregon, not Maine. I was in Portland. I was elsewhere at the time. There's evidence of that. There's people that saw she was at a family wedding. There's going to be pictures at a family wedding, people that saw her there, witnesses that could come in and say she was at a wedding. I was there with her without her having to testify she was there. Plane tickets, the phone pings that would show you're out of state, whatever else it is. There's other ways to show you were somewhere else. So that is their notice of alibi. That most of that's going to come through cross-examination. Question, why couldn't they have said this before? Why wait till the last second? Well, they're investigating. It's ongoing. And they don't have to turn it over before they have to turn it over. So why not? They've got a lot of other things to do. So that waiting till the deadline doesn't, you'll all be surprised. Waiting till the deadline doesn't really bother me much at all, because I am a last second kind of a girl. So it's like, it's due this day, I'll turn it in this day. They've also done quite a lot. And there's a new notice of hearing from the 17th. Oh, that's the same one. So the things that were down are back up on the website now. When the website goes down like that, it's normally seems that there's new filings, but there will be a hearing on August 2nd on the evidentiary items. That's going to be the DNA and stuff. We'll see if the court sets a hearing on the motion to reconsider speedy trial. We haven't gotten there yet. Let's get to questions real quick, and then I have got to scoot. Let's get to questions. I've got questions. You've got questions. We've got questions. All right. I'm going to get to as many questions as I can. I only have a few minutes left, and I have got to scoot. Hopefully today's conversations were helpful. Thank you for having them with me with compassion. As always, Lawnards, you are the best. Thank you. Let's see. Sounds like pros does not exist. The limit does not exist. The limit does not exist. You mean the alibi? It sounds like they're going to bring it through cross-examination of the witnesses saying, but you can't prove he was there, right? And that might be their argument. What is my hair doing? How long has it been doing that? Rude. Rachel, thank you. Britney Spears' trial date set yesterday are May 13th to the 24th for the 12th accounting in 2024 and June 3rd through 7th, 2024 for the other issues. Thank you. And that will be in front of a new judge. We will circle back on Britney probably next week just to talk about what that will be. Did Brian's public defender from Pennsylvania ever get sanctioned for? I have no idea. I have no idea if anybody even complained about it. None, zero, zip idea. Nikki said, can you have multiple defenses, alibi defense, and some other defense as well? That's a strategy call, because if there's an alibi defense, what other defense? Like if your defense is I wasn't there, it's really hard to go, I wasn't there. But if I was there, then it didn't happen this way. That's a difficult thing to argue. Can he withhold the alibi until trial? No. If there are alibi witnesses, they have to be disclosed by the prosecution per the statute. And yesterday was the day that they had to turn over notice of alibi defense and witnesses. Of course, what they said is the defendant has a constitutional right, and if he chooses to testify, he might testify and give an entirely different version of events. And then the prosecution will say, okay, but other than you saying that, what corroborates that? Like, of course you're saying that. You're the one on trial, right? Did you see the confirmation from the lawyer on the legitimacy of the GoFundMe? I did not. Rebecca Schofield's lawyer did not get back to me. I had asked whether or not that GoFundMe that was up was a GoFundMe for legal fees, but the court did say, isn't that GoFundMe for legal fees? So it seems that the court is aware of it, but I did not hear back on that. Ann Bell said, EDB, I can't thank you and the Law Nerds for keeping me company while I sit in the hospital with my husband. His appendix burst Sunday. He's recovering. I'm glad your husband is recovering. That can be a very difficult thing to deal with. And I'm glad we're keeping you company, Ann. Here for the truth, said bless her heart. Yep. Nicholas asked, is she going for the hustler defense, people versus Larry Flint? Maybe. We'll see. If this case goes to trial, I mean, we'll just have to see what the court does. If this case goes to trial, I can't see the TikToker, given everything that we've seen from the TikTok creator, I cannot see this case resolving, because she's like, no, No, say I did make a mistake. Even then she wasn't harmed and I did nothing wrong. Like, she's arguing the people that work with the professor don't know her. She's like, her coworkers don't know me. It's like, you're on TikTok. Samantha said resting in bed with long COVID, and this is just what I need to distract from my symptoms. Samantha, I'm sorry, long COVID is so difficult. I hope you recover well. Raincoat Duck said, I will absolutely pass this on to her. I've been so appreciative of the legal analysis here. Well, you are welcome. I'm not sure which her we are referencing, but that's fine. Here we go. I went out of order. Friend of the professor here, and I've been following this case on your channel. Thanks for the analysis on this. Feels like a sanity check. This has got to be wild to experience. I'm going to keep covering it because I think it exemplifies the difficulty with defamation cases. What do you do when someone is attacking your reputation? And when you say, please stop, they are just like, no, fight me. And then you have to pay for it. It's very, very difficult. Griffin T in the chat said, I've decided to rename you Emily. Time is a construct. You don't expect me to be on time. D. Baker. Yes. I had a judge that used to say to me when I walked into his courtroom, almost every time I walked into his courtroom, Miss Baker, lost time. The only appropriate response to lost time is never found, Your Honor. And I was like, yeah, lost time is never found. Lost time is never found. Though a good way to live life, like choose to spend your time doing things you want to be doing, because facts, lost time is never found. I did try to respond once, time as a construct. It was not met. It was not met with the response that I had hoped for. Simply Bell said, actually, it's now called Xting. Sort of wish Elon had chosen Y. Xting. Or sexting. I don't know what is happening. I'm still calling Twitter until somebody tells me I have to change. I don't know what's happening. But when you log in, there's like an X now. But when you Google it, like the bird is still embedded on some of the websites, and there's still things like Twitter Blue is still referred to as Twitter Blue. It's just, the whole thing is wild, and I don't understand, and I don't know what I'm supposed to call it, and they're just, everything can't be X. Like, well, I don't know. Personally, I firmly think Carlee had an accomplice. By the way, I too love JB Bruno from WFLA. He's amazing. I think so, and I think there's a lot of room for independent, well, not independent reporters, but he's a collaborative journalist on the internet where people help have the conversations, but also help parse fact from speculation, from rumor. I think there's room for all of that. We're going to do a little fact from rumor in a minute as we close out the show. Elizabeth said, I live in Mobile, Alabama. Female friends all across the state were terrified kids were being used as bait. They all said they would have stopped. Now they are pissed. And I get that, because the story that Carlee Russell created, calling 911, I see, because who does that? If you know it's fake, you call the police instead of just calling family and say, I'm seeing a kid, I'm walking down the side of the road, I'm going to ask if they're okay, then I'm going to call the police, this is where I'm at. I don't know. And then they hear a scream, but called the police and reported it. Stopped on the side of the road, heard a scream. The family heard a scream, and then all the tracking devices are left in the car. It's scary. And it plays on our fears that women do disappear and aren't found. It plays on fears that you could be trying to do the right thing and in a situation that you didn't know. It plays on all of those underlying fears. And I think that's so hard. And a lot of people are like, but who would do that to their family? Like, who would tell their family, who would let their family experience that? It plays on all of that. And I think that's why people are one of the reasons, I can't say it's the only reason, one of the many reasons that people are so deeply frustrated with this. Very, very frustrating. So X is a band, and that's the only way it should be. My husband is a big fan of the band X. I've seen X perform a couple of times. My husband and I have a wide variety of musical tastes, and we humor one another. Mike Rosso, I think I pronounced that improperly, filed a patent infringement because of the X. Interesting. Lawyers at Twitter, I don't know if this was just announced or if this was the rest of it, but yes, lawyers will be going, what? I'm curious to know how much these searches are affected by people not wanting to talk about what they know and saw and choose to mind their business. I don't know. And there's a lot that plays into that. I mean, there were places in Southern California where I worked that people were very afraid to engage with law enforcement because of their immigration status. So even when crimes happened to them, they were very, very, very hesitant to call law enforcement and ask for help. And that's one of many reasons why people are hesitant to ask for help and why some people just truly don't want to get involved. But hopefully, people will continue to try to assume the best, to try to say, first we need to find people. First we need to find people. First we need to believe people. And then we can ask questions, especially when people go missing. And I think there's room for trust and verify. Majestic Mythics Art said, I've seen a YouTube video. Someone went to where her car was on the interstate and there is a trail and tunnel right there. I don't know if there is, but I'm sure people have investigated it. If there is where you could go and get into a waiting vehicle, because how you disappear off the side of the road is a big question. I have not seen that. Dr. Patrice, it's good to see you. It seems like her parents believe that she was really missing. It did. People were also wondering if the boyfriend knew, and it seems like he did not know. The whole situation is sad. I agree with you. It's heavy and it's sad. And I very much hope, the same way that I said with, Amber Heard's testimony, people are like, this is the way that the media has treated her is going to change how victims come forward. I very much hope that that's not true. And I very much hope that this is not true, that it's going to change the way the internet believes people and believes stories when people go missing. I hope that it does not change people. And I think there's room for there's always room for trust and verify, but first goes with trust. Question, is there anything new going on in the Chippendales lawsuit? I have to look. I like that one. Oh, sorry. Microsoft filed the infringement. Wait, is Microsoft and Twitter fighting? Interesting. Smoke Signals said, I found an 18-month-old baby on the side of the road. It does happen. It does happen. Never crossed my mind it could be a trap. Family were horrified. He got out. It does happen. We saw it pretty widely reported with one of the Duggars that one of the kids had gotten out and was by the road. There was a kid who had gotten out recently, maybe in Florida, that had gotten hit by a vehicle because it had gotten out at night. It does happen. And all the pieces of the story played on it does happen. And that's hard. And then leaving behind all of the tracking tech devices and leaving her wig behind, and whether that was somebody taking her, trying to change her appearance so she wasn't as easily identifiable for the pictures that were on the internet. Like, all of it played into people's fears. Truly did. Is it legal for Jonah Hill's ex to release all those personal texts if recordings need two-party consent? Total rando question. Sarah, I'm going to have to circle back round. There are... When it comes to expectation of privacy and text, it's different than recorded conversations. So I would need to look at because California has some different rules with regard to privacy, and two-party consent, but some of that does not apply to text messaging. So it would just take me a refresh before I could give you like a solid answer, because I would need to go back and look at the laws on it, because it's not something I've been researching. Moo Boy Moo said, question, have you covered the Amber Heard lawsuit with the insurance companies? I have, but not recently. It keeps getting pushed because other shit keeps happening, but it's on my list for soon. Jessica said, Mandy Matney mentioned you in Cup of Justice this morning. Is there an interview coming soon? Yes, there is. ZH said, I've watched the Carlee case from other creators, but Emily, you do it the best. Drinking coffee in North Carolina, USA. Thank you. I know Natalie Lawyer Chick has covered it. She's also absolutely incredible. I've not watched a lot of other coverage on it. I very much wanted to cover what happens now. Her defense attorney giving a statement that makes admissions is very telling. So there's that. It's sad all the way around. Adelise said, Emily, I tweeted you. Would you consider a new interview with Jay Edelson? I'll ask him if he has much to say. I will. For sure. Let's see. Just got my neuropsych results, ADHD, depression, anxiety, PTSD. Watching you led to get me tested. Diane, look, the more you know, the more you know. I'm proud of you because now you know how to start walking through it. It's not easy, but you can't walk through it unless you know. So congratulations. Good for you. It is a hard step to take, but we do better when we know. Peter Mon says it all the time, and it is, I believe, a Maya Angelou quote, not a Peter Mon quote, but I hear it from Peter Mon all the time. When we know better, we do better. That goes for so many different things, including when we know ourselves better and know what's going on with us and can work with that. The chat is now saying, I'm not laughing. Diane, I'm laughing at the chat saying, Emily, I X'd you has a different ring to it. Yes, I don't know what it is. Zeeted. Can we just call it zeeted instead of tweeted? Zeeted, yeeted. Maybe that's yeeted. Maybe I'm just calling it yeeted. Maybe that's what it is. Maybe we'll just call it yeeted. I don't know. So let's see. The Double Helix said, yes, the potential safety of victims is far more important than not being made a fool of for believing a hoax. And I think, again, I don't think the public that believe the story is. I think what we saw from the public and particularly from the local community is how much they care. And I don't think people can ever be made foolish for caring. I think that if you care first and you get somebody home first and say, we want to get her home, and now we have questions, I don't think there's anything wrong with that. I don't. All right. Speaking of believing things on the internet, we need to talk about one more thing before we go, because I think this might be a new thing. We'll see as they come up. This might be a new thing. But I got messages from a few friends about a Formula One press conference. So we're gonna need to just go to this press conference real quick as we leave out for the day. I'm not anyone Formula One fans. Where are my Formula One fans in the chat? This is not hugely my world, but maybe it needs to be now. So Formula One press conference about Mercedes fan behavior. We need to talk, y'all. Hopefully you can hear this.
Thank you so much for being here. Today, the FIA and Formula One would like to issue a warning to the fan base of the Formula One team Mercedes-AMG Petronas. There is apparently a subsect of Mercedes fans who are attending Grand Prix dressed as wizards from Hogwarts.
How dare the Petronas fans dress as wizards?
They wear robes, scarves, and carry wands while greeting each other by daintily yelling, Petronas! And waving the wand as
not the daintily yelling Petronas and waving their wands.
Such. We understand that there are 4 quote-unquote houses within this subsect who refer to themselves as Hamilpuff, Russeldor, Toto Claw, and Slytherin. These fans have allegedly been sneaking butterbeer into the racetrack. They have also been somehow
not the
sneaking
butterbeer.
Owls. I don't know how, but it needs to stop.
You can't sneak owls into a Formula One race, people. What is happening?
While these fans are not considered to be armed and dangerous, they are annoying. So we ask that you please avoid any interactions with them at all costs. And to these fans appropriating wizard culture at the racetrack, we ask, please stop referring to race control as the Chamber of Secrets.
Isn't race control the Chamber of Secrets, though? Isn't race control the Chamber of Secrets?
Please stop calling Charles Leclerc the prisoner of Azkaban, and please stop referring to Max Verstappen as the Half-Blood Prince. This is a serious sport, and it needs to be enjoyed with dignity and respect.
It is a serious sport, people.
Thank you.
No, notice no questions. For things that made me laugh on the internet, this is 1010. The camera shutter noises are fantastic. The use of microphones are not media microphones. The green screen is so good. The green screen is so good that it absolutely made me giggle. So this creator, this is a TikTok. The creator is this James Coker, Coker. It's absolutely hilarious. It's spot on. It's so well done. It is so funny. And when people send it to me with a straight face, I was like, wait, is the Mercedes team named Petronas? Like, I have questions. It's just so well done. So if you need a giggle on the internet and you're not, and all you need is not Wingstop, then this is what it is. Oh, let me grab the link. All right, I'll copy the link so we can drop it in the description. But something that made me laugh on the internet at the end of each thing is what it is. So something that made me laugh on the internet. This made me laugh on the internet. The Mercedes team Petronas fans sneaking butterbeer and owls into Formula One racing, being annoying. It is such a great mockery of a press conference. I just absolutely enjoyed it. So this was too funny. I hope that it gave you a giggle. I will see you guys on Thursday. Have a good one. Take care of yourselves. Take care of each other. Thank you for having conversations with me on the internet, and I will see you in the next one, Law Nerds. Take care. Don't forget to show the podcast some love tomorrow. I will be in and out of the chat, but I'm still going to premiere it. So don't forget to give it some love. All right. Talk to you soon. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.